pretty, I goddamn. Goddamn, sooner or later, I'm gonna have a goddamn pretty eye me take though. I can't deny her though. Goddamn. Alright, pretty, I goddamn. Goddamn, sooner or later, I'm gonna have a goddamn pretty eye me take though. I can't deny her though. They my bestie, she's my bestie, that's my bestie. Your pair of eyes had me paralyzed. Toxic nigga, but you made me to a better guy. Smoke, but with you on forever, ever high. Can watch you all day, girl, like you televised. You think like this nigga, they ain't never lied. I lived the beaches alone, I had to pick a side. Look in your eyes, girl, you were hypnotized. Of course, it was your breasts, hips, and them damn thighs. Close my eyes, I'm still mesmerized. To get mad at my bestie, I tried. That's my bestie, my pretty.
I heard she's the one, she's got it going on. That's my pretty eyes, baby. Yeah, yeah. She don't take no mess. My bestie is the best. That's my pretty eyes, baby. Yeah, yeah. I heard she's the one, she's got it going on. That's my pretty eyes, baby.
Hey, Lawrence, how are you? Thanks for coming in. I appreciate it. All right, I'm going to get to this court hearing. Okay, she just came back from lunch, so yeah.
May it please the court, I first want to thank Your Honor for the generous amount of time you're according to me.
Thank you. Go right ahead, sir. And take your time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I
This is the Karen Read trial in Massachusetts. She's accused of hitting her boyfriend during a snowstorm. They're basically they didn't do a good job in the investigation. He was found on a cop's lawn. Turns out her backing into him didn't happen. The federal government's involved, all sorts of stuff. It's just a weird case.
let's go off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, "Hi, Alan. Substance to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote the.
Hey, West Sider Rider, don't you start with them tomatoes.
It's good to have, if Your Honor can be, having tab 1, which is the March 22nd email, because I'm going to compare and contrast.
All right. Thank you, Lawrence. I'm glad you came by. I appreciate it. It's different from the mess. Let's say that.
Tab 1.
Oh my gosh, what are you doing?
to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email,
Yes.
and because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept, because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57.
Just so people don't know, I mean, if people don't know, this is the defense attorney. There were some accusations made about prior witnesses that they were hiding evidence from the Commonwealth when, you know, they weren't. And the Commonwealth has been hiding the garage video throughout the whole trial. They give them little snippets of it here and there, but they won't release the whole video or the metadata with it. But for some reason, they stopped the trial. I mean, stopped this motions hearing from last time because the judge was all shaken that possibly the defense was being wasn't handing over evidence, and they handed it over. So that's basically what he's discussing right now.
Hi, Alan. Subsequent to our conversations, he's quoting purportedly this email. On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And
Wow.
it's not merely semantical, it's the cutting off of communications. And it's unfortunate that pause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58. And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, touring requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
What time of day? Because if it's California time, it might be different than what we have here, but.
It probably will be, but I don't know what time of the day. I'm gonna ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
Okay.
All right.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And what
Do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
Oh my goodness. Like, really, does the time fucking matter? Does the time matter? They handed this stuff over before even they did the hearing. So they're not in violation. This is wild to me. And everything that was stated, like on those emails, that was from Dr. Wolf to Jackson, not Jackson to Wolf, but it was stated and then the voir dire and testified to in court. This is just crazy.
And I'm understanding Your Honor would like me to pause until you get
Judge,
that.
if we can, because I'm looking at a
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
I think it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
It is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. McCall.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Read ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the
But how can you say she's guilty if you haven't even seen the first trial or this trial?
explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top. And then we continue on page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58. line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer, Your Honor, gal. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you. Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
So
Subject.
that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor,
If it's with the
I
email,
was
then
going
it's
to give you
dated,
that
lady.
context for that.
Whatever.
Go ahead.
The
Anyway.
context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualify the expert. Is this all one document?
No, Your Honor.
All right,
And I appreciate the question.
What
So-
is the date of so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one?
The other one was sent the day before on June 22nd.
Okay.
I'm just going to give the name that the email has. I think it's wolf_quals document. Okay? So there's 2 emails. One's just the quals. The other, I respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says in the title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual.
They've been doing that to me too. Like they've been really hating. Like I'm not typing anything like controversial or anything like that, and they'll delete my shit. Like, wait, cut me a break, YouTube. What the hell is the problem? They do that to me all the time too. Like, let my comments through, mother effers, you know?
Quals document or the direct document, we produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is.
You're not supposed to say that. You're supposed to deny. But no, mine really haven't been disrespectful or anything like that, and they've been deleted. And I'm like, I'm not even saying anything wrong. Why you keep deleting my messages? But if yours were disrespectful, okay, I gotta respect that. So maybe they were deleted in good faith. That means YouTube's watching my channel. Woo!
Sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email.
Okay.
Hey, YouTube. Hey, this is an adult channel, and could you please like quit deleting my people's freaking chats, because I would like to read them. You know, it's hard for me to get engagement when I'm watching trials and stuff. So when I do get engagement, can you let it through? Let me decide whether it's distasteful or not. Man, quit babying me. First year, never mind. I'll talk about that on another live, not this one. But back to the trial.
The last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
I'm gonna
just
actually
went.
hold that thought. I just have one other thought about
Yes,
this.
please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
You are
correct.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
That, I
answer
just
is
wanted
no.
to be clear. That's how I.
That's her father. That's the defendant's father that's in the background. Who knows? It almost looks like the victim's family's nodding off because they don't really want to hear this. They think she's guilty, and I mean I understand that. She dropped him off. After that, she goes to go find him because he never came home, and he's lying on the freaking in the snow, on another cop's front lawn. Looked like he went 10 rounds with Mike Tyson. You know, she's freaking out. Doesn't know what happened. It doesn't know if maybe she backed into him on accident. Doesn't know anything like that. But experts have said that there is no way this looks like a car accident, that it looks like he was hit by a car. And they didn't check the cop's house to look through his house. You know, if it was you and me, our houses would have been raided. Plain and simple. If somebody's dead on our front lawn, our house would be raided. Well, the cop's house wasn't raided. They didn't even look into the cops. They just put their sights on her, and that's it. That's all. They ain't trying to hear no other sides of the story, nothing. The lead detective was caught talking about her in disrespectful manners on text. I mean, this case is wild. The whole case was botched from the beginning. I don't know anybody that uses leaf blowers and freaking solo cups to collect evidence, but that's besides the point. So yeah, anyways, he may be nodding out because I mean, dude, it has to be thorough because the Commonwealth, they were lying on them. They were lying on them. And the whole thing is now she wants to go, well, was this disclosed before the first trial? This shouldn't be about the first trial. You had a voir dire in the first motherfucking trial, lady. This is the second trial. But whatever. Okay, back to the thing.
That's how I see it. I just wanted to give you the opportunity to tell me if that's accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or
Okay, hold on. I don't know what happened. Hold on. Hello. Okay, I'll have to be right back because I don't know what the heck is going on. So just give me a second.
Only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today, and then Your Honor continued on page 61, line
Hey,
12.
James.
And Mr. Brennan, where the federal authorities have been kind.
Hey, James, how are you? Thanks for stopping in. I appreciate it.
Enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court. I might have asked for a sidebar and come up and said, Your Honor, my bad. This is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARPA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARPA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government, it was the defense. February 13th, they sent us the emails and the direct examination outline. I think I said that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just the emails.
I thought it meant everything, but.
I don't understand how that conclusion can be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
Because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, and you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do. But if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this, being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again, because I was curious about the changing position on February 6th, that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA, because that would naturally preclude the defense from retaining them. So we refrained, and we will not reach out to them. This is really an interesting statement, because you read it, because that would naturally preclude the defense from retaining them, yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize your honors giving us that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move.
They also should go about the
efficiently through the
the
next
harassment they got.
step,
All right,
which is
and
to point to the Massachusetts rule and give the court my view, and I have to reference because Your Honor brought up
Again,
some.
you don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to
this is dumb. I don't know why I did that.
Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false. it has to be knowingly false, of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th, there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yannetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What
you.
page are you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Buchalter, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court, move to exclude the witnesses? Mr. Brennan, yes. The court, what do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court, I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional.
It was all in the documents
that
they released.
I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when then we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important, the court, if I don't exclude it with other side seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided, the federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth.
Wow.
On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're gonna collect, here's what we're gonna turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any read of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the clause, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when. And so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances, and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements, and she made misstatements in fact about the financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In some, Mr. Yannetti's statements on June 10th, all completely accurate, Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, etc. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. but I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry, okay. So my point is, we produced the discovery. Why is there still an issue with ARCA? These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here.
Yeah, don't tie their hands behind
Now
their back.
to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it? The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped, and I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the U.S. Supreme
Counsel pro hoc vice, or was that?
I'm gonna get to that. The answer is the counsel.
Stop interrupting him, Judge.
My answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted, and it wasn't a revocation of pro hoc vice. There's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor,
Of course, she's going to take
there are other
it under
cases
advisement.
when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so The violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not, for the trial, the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right?
Right, exactly. The defendant needs, I mean, this is absolutely ridiculous. Brennan knew what the hell he was doing.
And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th? There were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say this as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we made mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can and certainly can. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
Oh, for fuck's sake, lady. So we're taking a breaky break. Hold on, let me.
You are muted.
Let me full screen myself. All right, we're taking a break. I don't know if they're going to leave the stupid microphone on, but yeah. Okay. Anyways, hey Daniel, how are you? So we're taking a 10-minute break because, you know, the judge always needs a 10-minute break. Oh, wait, I can see. Hold on. Because I know I'm behind, right? Okay. I don't know why. Okay. I knew I was behind. Anyway, so they're taking a 10-minute break. Basically he's saying that they misrepresented how can I say this? They misrepresented the reciprocal debt or info. So Brennan knew what he was doing. He don't like the FBI. He hates the FBI. Because they weren't on his side way back in 2013. So he has a vendetta. What's that, Mad? So he has a vendetta, and he's trying to do anything and everything he can to limit the defense to having uh what do you call it? A real defense. And I think it's just a bunch of crap. I don't like it. I think that if you have a solid case and you know what you believe to be true and the facts are on your side, you don't have to do all this. Like, you don't have to do all this extra stuff. This poor woman has been on trial already, had a mistrial, should have been acquitted on 2 charges, but they're fighting that in court right now. And then now we're going through motions for the second trial. This is absolutely just bonkers. So yeah, I mean, so he had to be thorough, and I understand. Like, I'd want to be thorough too if somebody was misrepresenting what I had to, or what my defense or my co-counsels are doing. I mean, and trying to get them off the case. She should be entitled to whoever she wants, because after all, it's her life on the line. It's nobody else's, it's hers. And, I mean, it's sad that they get to do all this because they have immunity. Like, it's not fair. It's not right. I think everybody should have a fair trial. They've been doing this way too long to people, mainly people of color. They've been doing this too. They want people to plea out because most of the time they give you a sweet deal if they have no case. Well, this case, it's a police officer, even though he died on another police officer's lawn, and they didn't fully investigated. They used leaf blowers and solo cups to collect evidence, and all the investigation was very shady. The lead detective is text messaging people saying he hasn't found any nudes and all this other crazy stuff. Like, this whole case is wild. And the federal government, they told the district attorneys that they couldn't see in good faith them going forward with this trial because her SUV did not hit the victim, and the victim did not hit the SUV. So what else does that leave that to? Probably the people that live in the house or something else. But they didn't fully investigate. They set their targets right on her because she's not law enforcement. So there is no thin blue line to protect. That they protect their own, and it's a bunch of crap. She's an outsider. She doesn't live in Canton. All this stuff, it's mind-blowing to me. But yeah, so we're on break for 10 minutes and I'm just rambling on. So I don't know. I like trial watching. If you like courtroom drama, I do because I like to see how the justice system works. I like to see what they try to do to people, and it's not fair. I mean, this is This was the first case that I seen the corruption, and then I seen the YSL corruption, then I seen the ASAP Rocky bullcrap. I mean, like, how many more other cases are they going to do this? But they want to get out they're one of the attorneys because they didn't hand over reciprocal evidence, and they did, so he totally lied. But but every time they've been waiting on this stupid Sally Port video from the very beginning. It should have been memorialized, saved, all that stuff, and it never was. They've been fighting to get that. But yet one thing that the Commonwealth says, then she throws a tantrum and says, "Oh, we're gonna have to stop this until next week." What, lady? Because he misrepresented what happened? How many times are you going to let him do this? I wish I could be better with my words, because I got so much to say, and my mind goes everywhere. My ADHD is wild when it comes to trials. But yeah, everybody is entitled to a fair trial. I don't care who you are. And it really sucks that the only time we really get a fair trial is when we have money to pay for one. Like, if you don't have money to pay for one, man, them the public defenders, all they want to do is hurry up and make you plead to something, and then either you get out on probation and you're under a babysitter for 5 years. Most people don't make it out of that. But even if you're not guilty, they just want you to hurry up. It's a rotating door. Hurry up. I've got this magnificent plea deal. Go ahead. And most of them don't want to go to jail. Most of them don't want to wait for a trial. So they plead guilty to crimes they don't commit. But I think we should hold the states accountable, make them prove that they have a case and that we actually did it. Not this, circumstantial, you were in the vicinity, but 5 other people were there type deal. Even when the dude passed away, he passed away at the hospital. But even when dude was found, like, she had been gone for 6 hours. Who knows how long he had been out there, but as far as she knew, he went in the house. And because she has medical issues, she had to leave because her stomach was giving her problems. So she was mad, pissed off, had, left, calling him, screaming at him, thinking he's cheating on her because he didn't come out in that 10 minutes. She leaves, go back to the home, and at the time that they say that this accident occurred, she was already back at the house. So, whatever. But yet, they claim that he was on the lawn since she left. Well, how come nobody's seen him on the lawn? You can't tell me when there's only like 3 or 4 inches on the ground, you can't tell me you can't see a body laying there. Oh, it wasn't even 3 or 4 inches. It was like barely dusting at the time. And at the time that he was found, it was like 3 or 4 inches that he was in. Like, barely. And then they waited till they had 1.5 feet to go out there to search. And then all of a sudden they're finding these tail light pieces. Give me a break. Give me a break. And you don't have no reports, no nothing that shows when you went out there, when you found it. Yeah, you took pictures, but who's to say, there's just no reports. Pictures don't mean crap. How can you tell me in 3 or 4 feet you can't see you can't see any taillight pieces, but in a foot and a half you can. And then it looked like it was already on top of the snow. Like it was just planted there, like woohoo! And then you guys, hurried up and put a shoe out in the snow when it wasn't found in 3 or 4 inches. Give me a break. I don't think justice for him is not putting the wrong person in jail. It's not. Or it's not even just it's just wrong. Eyes look green today. Anyways. All right. So I don't know. It's just, come on back, you wench. And this judge, like, she denies every freaking motion that the defense has, unless they agree upon a motion. Then she lets it through. It's just wild to me. But she lets all these Commonwealth, approved. But I just say quit tying the defense's hands behind their back. Quit trying to limit them on what they can bring, what defense they can put forth. If you have a solid case, you have a solid case. Quit trying to discredit witnesses that already testified in the first freaking trial. If they already testified in the first trial, it shouldn't matter. I mean, I don't know how they got to voir dire Dr. Russell twice. But then they want all these experts in that aren't experts to come in, like saying that the ground was frozen. If it's barely snowing, anybody that knows, lives in a place where it gets snow, you know that the ground doesn't freeze until the snow's on the ground. Until it starts getting really, really cold. So, and this was like their first big snowstorm or something like that, like of the year. Of January. Just things don't add up. Okay, here we go. Oops.
You are unmuted.
Have you seen it? Welcome back to session.
So before I hear from the Commonwealth, Mr. Leslie, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do, is you said I could ask questions of other counsel. So
Okay, I'll be in the
when I read
chat.
Fresh, I just want to ensure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Leslie? And what I'm particularly concerned about is what you knew or what you didn't know.
No, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
I'm sure the court did after it looked at the transcript.
No,
I did as well
no,
after I
no.
looked at the
I
transcript.
did long before I looked at that.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small.
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is.
No, hold on. Ms. Little, it's just thrown on you that you're, that you're responsible for all discovery, but the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay, so I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARCA was not wholly independent. It's information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations at the sidewalk. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know, a voir dire is inconsequential. I don't know what to ask. We can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses, and there is a very unclear relationship as we stand here right now, between the history of interaction between the defense and these ARPA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARPA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are 2 requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Lisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Lisi.
It wasn't a request, Your Honor.
You suggested that I call.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. The first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents were provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my 2 requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not correctly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th to ride on that same license.
And
There is a responsibility, respectfully, to Attorney Yannetti, a fine attorney, an excellent attorney who I admire. But there's a responsibility.
you don't admire him.
So
Shut
that
up.
there are not a number of pro-equity J lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge essentially of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask co-counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've done.
May I have a moment to speak to counsel?
Sure.
Thank you, Ron.
I'll need to call the United States Attorney's Office and get an answer.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies in the 24 saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it will be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer.
Okay, hold on. What does them, okay, hold on. What does them contacting the defense, but the defense not writing anything back, how does that have anything to do with it? I'm not understanding you, Brennan. Like, I'm not getting it. I don't understand. Like, they didn't ask them. They didn't prep them. They didn't do all this stuff that you're claiming. All he put is the qualifications and stuff like that. That was it. And Jackson said it last trial. I know he did. I wish I could find it, but I know he did.
So inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the board here, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial,
What date?
day 26
You
of
know, I know
trial,
that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearing. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross on the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the content of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's day, I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number from the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, this is June 10th, 2024, trial transcript 28.
Hold on one second. Let me go with that.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important to the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. on page, on June 18th, 2024. The voir dire hearing.
I wish the defense would go back and look, because I could have sworn
The court
that
asks,
this
well,
is
I
all
thought
said
that
in the
you would
first
help-
trial.
I've got the transcript. What page you want? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up.
Look at Jackson. Jackson's like, fuck this shit. F this shit. Well, it looks like
Page
Leslie, you're gonna have to come back next
So
week.
the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rensler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterization,
Oh my gosh, stop.
unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the
I
voir
really
dire
gotta go to
hearing,
Streamlabs and change that, because
page 71,
I can't do it. I'd rather have Nightbot.
Okay.
line 4. Importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked in the court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making?
Oh my
to the
God.
court and to the Commonwealth? Is that a genuine impression consistent with reality?
I have a question. Okay. The last time he said it was a trial by ambush. How is it a trial by ambush when these witnesses have already testified? The person that asked the questions is your co-counsel. Just because you just all of a sudden came in this case because you're doing Morrissey a favor, the district attorney, but the co-counsel was the lead prosecutor in this first trial. Why are this is whatever. I guess it doesn't matter that they already testified, right? I guess it don't matter. And so now you're screaming, oh, it's violation. Dumb. Absolutely dumb.
Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARC are wholly independent from each other. This is also consistent.
Of course they know who they don't know her, but they know who she is. Why? Because, hello, they were asked to do this case to check to see. They know that she's the defendant. Of course they know who she is, but they don't know her. They've never seen her. They've never talked to her. You are so misrepresenting what was said, sir. I hate that you're playing defense when you're supposed to be on the offense.
With the representations regarding payment. There are questions voir dire and at trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024. It's addressed to.
Hold on 1 second, please. Okay.
It's addressed to Attorney Jackson. And the position that the defense takes, Attorney Lisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. Our experts knew. Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office. 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024. And these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel.
The defense thought that they were going to be paid by the FBI. They had no clue. It was a shock to them. See, here you go misrepresenting shit, saying, oh, well, they didn't hand over everything. What? Are they doing what you've been doing this whole time, Brennan? Because that's what the Commonwealth has done. They have, let me hand you a little bit. Oh, we found a little more piece of evidence. We found a little more piece. Oh, we're already in trial, so here's this little evidence. Oh, don't matter that it's reversed. It's looks like it's on the passenger side when it's really the driver's side of the car. All this stuff that you guys have done, the Commonwealth. But you want to cry.
None. So the only
But your case is strong, right?
people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? whether any documents.
They handed the
were any
emails
outlines,
over, sir.
whether was there any discussion about the potential testimony, or is this solely the preparation?
See, this
of
is why I
Dr.
don't get in
Renshaw on
trouble
his
with the
own?
law.
On the
Fuck the
same
law.
day, 3 hours billed by Dr. Wolf, prepared for testimony and hearing.
I mind my business and carry on.
Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was.
Shut
We didn't
up.
have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by
I'll be in
Dr.
the
Renshaw,
chat.
and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Renshaw prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Renshaw on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and Court never knows about. Talk about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation, nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story, a fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when we look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6. That's the motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions, and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for sake of the press and the public, we'll have the trial, and we'll vet it at trial. when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did
Any
they?
particular page you'd like to read without citing?
Yeah. If you look at the first page.
Yes.
Yeah,
You don't have to read any of it, you just tell me the paragraph.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we'd be oblivious if we stood here and said that the relationship between the defense and the experts, there was no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline, it's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations or communications the defense had with the ARC experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right, thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they had been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That's a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about what he said, that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
Yep.
go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony. And let me be clear on what I mean by retain. He didn't testify.
It's been a long
I
day.
understand. I'm trying to answer your question.
Oh,
I know,
or
I know,
you,
I think
Judge.
that's something that you want to explain. Go ahead and explain.
Right. So what I'm saying is,
Fuck's sake.
in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire The voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this third person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses because we weren't talking about the third. The third was Dr. Russell.
Hey, bro, how are you?
You'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Unity, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped on
Page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100%
It was disclosed.
true, because
I read that earlier.
Right, but Mr. Brennan just mischaracterized it again because that is 100% true. He made it seem like that was an untruthful
Let's go,
statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February.
If she, I'm trying not to swear, if she excludes him as a defense attorney, I think it's BS because Brennan, the prosecutor, has fed her nothing but lies. He's mischaracterized everything. And then trying to say that they're hiding stuff from him. Well, what about the Sally Port video? The main piece of evidence. You've been hiding that before even the first trial. But, okay, we want to cry because it's so not fair type of crap.
This is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions to follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Canoni was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard and got the order, because that's the first she knew of the inquiry, she gets the order. I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no, I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back, I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.38. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Miss Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it. And I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant, their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brown?
Very briefly.
Oh my God, I don't want to hear his whining. But anyways, yeah, they could be a bit complex if you don't pay attention. This one's wild. You really have to pay attention, or you're gonna be lost in the sauce. Because this is wild. They've already gone through a first trial. This is her second trial. It's just crazy, and he mischaracterizes so much. It's beyond me. He says, like, anytime he talks to the defense, that's not what was said. That's not what. But come on, dude. This is what you do.
Arguments of the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation.
Verbal gymnastics. That's what you've been doing, Brennan.
Distort reality.
Remind me never to break the law. Remind me to watch my surroundings so I never have to deal with the law, because this is nuts. This could happen to anybody. Anyways, especially if I'm around cops, man. Shit. No partying with cops. No dating a cop. That way, if something happens to him at another cop's house, I'm not getting accused of doing something, because this case is wild.
Is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in the pleading.
That was filed late, right?
February
Or
6th.
Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Manetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not.
Ms.
right?
Little has
It's
only done the
maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Yanetti. And this is the defendant Karen Reed opposition to Commonwealth's motion to exclude employees of Arca LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of Arca LLC, namely Daniel Wolf, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense. It is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony.
She let out a sigh there.
Reaching the jury in this case. I know Attorney Lisi no likes the word retain, but that retain word has import. There's a reason he said it.
Because that's what you do, is retain a
Their
witness.
motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday.
I knew she wasn't going to finish out the day.
Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes,
come here immediately afterwards?
sure,
Thank you, Your Honor.
sure. All right, but we'll see here, Jim, we have these all scheduled at 9.
We do.
Okay.
I hope they order a stay. I hope the federal government orders a stay. That would be a wrench in their side pocket. Because this
9.
they're trying to tie her hands behind her back
Wednesday
and say, no, you can't defend yourself.
And also Friday. All right,
So-
so see you next week.
I guess Tuesday and Wednesday of next week. They're coming back for more motions. They couldn't finish today, so they have to come back next week. I don't even know why you're shaking his hand. He's a dick. Common courtesy. That's nice of you, Yannetti. It was very nice of you to shake his hand. Wow. What a douche. Okay, let me stop sharing the screen. Okay, so I need to make myself big. Hi. Okay, so I guess that's the end for today. They come back next Tuesday and Wednesday for more motion hearings. They also have a federal court hearing on the 5th. So we won't know anything about that unless, there's something that's put on the docket. I truly hope that the federal government stays this, because I wish they would put more info out there. Oh, hold on a minute. Shut up. Okay, let me get out of you. Okay, anyways, okay, I'll try to be there, that's for sure. I'm probably gonna take a nap and then I'll be up and ready to go. But so anyways, so they have a court hearing about the first and third charge being acquitted. And hopefully they're going to add all this shit, because this is wild to me. And we won't hear anything back from her because she never makes a ruling on the bench. She always says, Furl, I appreciate you. Appreciate you. Anyways, so yeah, she, so frustrated. Anyway, so this judge is very biased. I'm just gonna be honest. Every motion that they bring up, it gets denied for the most part, unless it's agreed to by both parties. And I think the Commonwealth is just doing anything and they can, trying to say, oh well, I'm not trying to exclude them from having experts, but yeah, you are. You're trying to exclude everything that they want to bring forth. You're mad the federal government is involved. You have issues with the federal government. So does the district attorney, the lead district attorney. It's been very biased. Anybody anybody that has a dead person on their lawn, you guaranteed our houses are getting searched. But because it happened on a cop's lawn, nope. We'll just say that she hit him. Even though she only had a cracked tail light, and it was only cracked a little, not a lot, until they got a hold of it. And then he was found in 3 or 4 inches of snow, but no taillight pieces were found. They were using leaf blowers and solo cups to collect evidence. Let's see what else. They took her car to the police department where they were recused because of conflict of interest, all that great stuff. A whole bunch of stuff. It's just, and then they've been waiting on evidence. The evidence from her car being in that Sallyport, that's what they call a garage. But the Sallyport video of her car being in there, they hand them little trickles of evidence, but don't hand it all over, which is ridiculous. But now because the prosecutors think, oh, well, they were talking this whole time, but they weren't. Like, all the communication was just to schedule a time for them to do the voir dire and all that stuff and get qualifications. I mean, there was no emails back, but they want to say, oh, we're missing emails. We're missing emails. Well, how does it feel? Okay, just because the Commonwealth is dirty doesn't mean the defense is dirty. And if you have a clean case, you shouldn't have to play dirty, right? Why are you playing dirty if you have a case? But all right, I'm out of here. I appreciate everybody that came through. Lawrence, Room Shaker, Mad TV, who else? Hood, West Sider Rider. Yeah, everybody that came in, thank you so much. I appreciate the support. I'm on the road to 1K. I'm trying to get them watch hours. So yeah, like, if you decide to subscribe to my channel, please drop down in the chat or in the comments and let me know what you feel about this case. If you knew about this case, yeah. And I really am trying to get better at my speech. It's so hard when you're an introvert. Like, but anyways, I really appreciate each and every one of you. Thank you so much. And I'm really trying. I'm gonna get there. I'm gonna get there. That's my goal for 2025. I'm gonna be monetized by the end of 2025. I'm gonna be doing the dang thing. I mean, you should subs to me because I keep it raw, real, and uncut. Like, I watch it from a juror's perspective. But thank gosh I'm not in the courtroom, because let me tell you what. I wanted to be a lawyer. I love this stuff. But sometimes I just want to reach out and slap somebody. Thank goodness they don't have slap-o-vision, because the state, when they play dirty, they can play dirty. Like, I expect that from the defense, but the state, come on, you're supposed to be held at a higher level, and you're not. Like, you're not playing by the rules. I mean, and the state gets more the state gets more leeway than the defense. And I don't feel like it's right. Like, okay, yeah, it's their burden, but at the same time, this is somebody's life they're messing with. And it could happen to any one of us. We could have a friend or whatever that may be on the police force and they end up dead on the side of the road at another cop's house, but they don't want to check the cop's house because, that thin blue line and stuff. Oh, they can't do that. They can't go in and check the house, make sure nothing happened at the house. Why? Because you just take their word for it. Oh, he never went in the house. People lie. Hello. Like, this is beyond. And just because she backed into his car early that morning to go look for him and cracked her freaking taillight, all of a sudden it's in a million pieces. But it's so funny when they tow her car. The one cop that it was, the city that it was in, he went out there with him because it's his jurisdiction. So he went out with the detectives and he looked at the taillight and he said it was cracked, but not all the way busted. But they're claiming it was all the way busted. So it's just odd to me. Then you have the lead investigator text messaging all his friends, high school friends, whoever, text them about her medical condition, saying, oh yeah, I'm going to make sure that she rots for this, all this other stuff. 16 hours in, how do you know? When you haven't even done the proper freaking investigation. You've talked to these witnesses. Where's the recordings? Oh, that's because you went to their house. Excuse me? When you're trying to find out what happened to somebody, you don't do it at their house. But because it's a cop, you give them leeway, huh? And then you let the PD department that recused themselves, you put it in their Sally Port, and then all of a sudden their videos are missing and all this other stuff. This case is absolutely crazy. Crazy. And what's sad is his family believes the state. They don't want to give her benefit of the doubt. Because why? Oh, well, she shouldn't have left him. Well, she thought he was going to be right out and she was having medical issues. So she had to go back to the house. It wasn't like she thought he was going to come right out. He didn't. She waited 10 minutes. But then she gets home at the time that they say, back at his house, at the time that they said that it happened. How in the hell do you run somebody over when you're across town? How do you do that? How do you do it? And nobody sees his body on the lawn that we're leaving it way after she dropped him off? Nobody. But it's right there in the front. Right there by the flagpole, but nobody sees it. Oh, look the other way. We ain't seeing nothing. Right? So something happened at that house. How come he's got dog bite marks all across his arm? If he wasn't in that house. You're telling me so you let your dog out and just, she had a treat? But now the dog's missing because why? Oh, we can't have that. We can't have our dog involved. We got to hurry up and get rid of the dog. But now all of a sudden, oh, the Commonwealth can produce this dog? No, this is a bunch of BS. And then now they're trying to say the ground was frozen. Anybody that lives where it snows knows the ground doesn't freeze until snow has been on top of it for a while. How do you find taillight pieces in 1.5 feet of snow, but you don't find them in 3 or 4 inches of snow? When you're using leaf blowers and all that great stuff to, melt the snow to try to collect blood evidence and all that other crap that you're doing? Really? And then you don't even properly store them. You put them in red Solo cups, put it in a shopping bag, saying, oh, well, we didn't have anything. We're just a small police department. Every police department has special evidence collecting stuff, no matter whether I mean, how many, we don't know how. I mean, even if you have one person murdering another person a year, you still have those little cups. Or you call in people that do. You don't touch it until somebody else is there. But you recuse yourself early in the morning, and they don't even try to search till there's 1.5 feet of snow on the ground. They confiscate the vehicle. They confiscate her phone. They were looking and found out that she was calling an attorney. Oh, she must be guilty because she was driving drunk. She thought that's the least you could do to her. She didn't know you were going to get her for manslaughter and all that other stuff. I mean, seriously. And then your witnesses are combative, all sorts of stuff. It is just, this case is mind-blowing. Mind-blowing. You're letting your witnesses bring in evidence, but you didn't collect it yourself when you should have. Anybody that is involved in a case that's a legit case, they will search your phone themselves, not have you bring in pictures and all this other great stuff that you can Photoshop. Make sure that you don't have marks on your hands. Make it look like you weren't in a fight. Hurry up and dispose your phones so they can't get your text messages because you were there that night. And this is the defense doing it, not the investigators that should have been doing it from jump. This case is absolutely crazy. So I hope everybody is along for the ride. There are people that find him guilty. Find her guilty. I understand. Hey, we all got two eyes, not the same view. So I don't. If you think she's guilty, she's guilty. I don't. I don't. I personally don't. They have not proven to me, but beyond a reasonable doubt to moral certainty, because that's the highest you could go in the Commonwealth. They haven't proved that case. And the only reason why maybe she would be guilty of manslaughter is because they think, oh, well, she left him. If she didn't leave him, then he wouldn't have died. That's not her fault that he died. He's an adult. An adult. She thought he went in the house. He was supposedly hit or whatever after she left. But anyways, okay. I appreciate all the support. Thank you, bro, for coming in. I appreciate you. You already know that. I appreciate each and every one that came in and was chatting with me, had me laughing, just listening. I appreciate you all. And I hope you all have a blessed day. I will find something for tomorrow. I don't know what, though. I thought that there was going to be a Yak Gotti hearing, but I'm not sure. So if there is one and it's televised, I will be doing that one. But other than that, I probably will be just watching little court hearings, like from Texas or wherever, like little court hearings. So nothing too major. But this is the case that I'm really this is the first case, I believe, that's coming up. It's her trial. And then let's see what else is there. I believe her trial and Corey Richens, which is happening in my state. She's accused of poisoning her husband with fentanyl and then came out with a grieving book. Anyways, that case should be going on too, which I'm not too interested in it. I really don't care if she did it or didn't, whatever. Because how many times have people done that and got away with it? Overdosing somebody on fentanyl is hard. It's just hard, especially if they're drug users. But that case is going on. Melly's isn't until September. Somebody's was in July. I know Brian Koberger is in June, I believe. June or July. That's the one that unalived, got a little pokey, got a little stabby, with 4 students from Idaho State. That trial's coming up. That should be interesting. Yeah, just a whole bunch. And then the Diddy trial is supposed to be starting as well in July. That's the other one. So I kind of want to talk about that a little bit. I will be watching the recaps for the day to, come up with that. I'm trying to do the dang thing. I hope that you subscribe to my channel. I hope you enjoy it here. I don't care if you have a different opinion than mine. Just keep it respectful. That's all I ask. Don't call me a dumbass, because I'm not going to call you a dumbass. I actually like hearing other people's point of views. I really do. Because it helps me look outside the box and then come to my, conclusion of what I really think it is. So yeah. Anyways, all right. I appreciate each and every one of you. I'm going to end now. Everybody have a safe, blessed day. And remember to let the ones you love and care about, that you love and care about them, because tomorrow's never promised. All right. Be safe out there.
Put your eyes on me, like the spotlight. Recognize me, showing love and got my grind right. And ever since day one, the love been on side. And since you got my back, I got your back for life. Yeah. Pretty honesty, know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you down, just what it gon' be. Definition of business, definition of friendship, definition of rider, definition relentless. She's a strong man, she's a sweet lady, she's a great mother, your pain get aching. Yeah. I made that girl on YouTube. She never dissed my life or put me in her dark mood. And I thank you. You appreciate it. You're my favorite girl on YouTube, and I can't fake it. Still got faith in me. Make me feel like big. DJ Khaled voice. Pretty ID. Still got faith in me. Make me feel like big. DJ Khaled voice. Pretty ID. Made a little shout on this show called BGP, you know what I'm talking about? Shit. We been cool ever since, my nigga, you know what I'm talking about? Put your eyes on me, like the spotlight. Recognize me, showing love, done got my grind right. Ain't ever since day one, the love been on side. And since you got my back, I got your back for life. Yeah, pretty honesty, know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you down, just what it gon' be.